Um, so my understanding is we've got an inquiry as to Cedric Taylor. We'll talk about that in a second. We are trying again with a plea with Mr. Gooden, and we're going to do something with Mr. Palmer, and then I think we're patching Mr. Dean in via WebEx.
Yes, that's correct. Judge number one, I think is going to be a plea.
Okay.
And Mr. Palmer, he's in the state system. I think we talked about this with his co-defendant last week. So both of the cases have been moved to November 16th. So Mr. Palmer will not be, he's taken off the calendar.
Okay, so Palmer is off. You said he's in the state system?
Correct. He's in Jenkins Correctional Facility.
Okay, well, so Dean is also in the state system.
Yes, but we did not find out about Jenkins being in the correctional system. We had already set up Dean before we found out about Palmer. So
Okay.
Dean is set up for you to go ahead and put the offer, his final plea offer on the record.
Dean will do with him at 11:30. So Ms. Sellers, is it correct that you believe it'll be a plea for Cedric Taylor?
Yes, Your Honor.
Okay, who is representing Mr. Taylor?
Ms.
my case, Your Honor.
Snyder. Oh, there.
Ms. Snyder is not Leslie Simmons. Oh, look at that, there it says Ms. Snyder. How about Mr. Taylor? Do we know how he's connecting with us?
He's supposed to be on the Zoom. I gave him all the information yesterday afternoon.
Okay, well, what if I see that Ms. Hornsby is on, but I don't see Mr. Pinion.
Good morning. Good morning, Your Honor.
Good morning, Ms. Hornsby.
Yes, he's trying to get on right now. I'm communicating with him by text, and
Okay.
he's trying. Yes, sir.
It looks like there he is. We're missing a prosecutor. So maybe Mr. Pinion will get on, and we'll just go with whoever is ready first. If Mr. Taylor gets on, we can take that plea because we've got lawyers on both sides. If Mr. Pinion gets on, then we can work through Mr. Gooden's situation because we've got Mr. Gooden and his lawyer. And I will just be here getting ready for those things. Do we know, Ms. Nelson, is it going to be Mr. Abate or is it going to be Mr. Pinion covering the Gooden matter?
I believe it was Mr. Pinion. Let me reach out to him to double check, Judge.
Okay, he's not late yet, but he may not think this was his case. Yeah. Just want to make sure that Pinion isn't thinking about it will be here again, or who knows.
Judge McBurney.
Yes.
I did hear Ms. Nelson discussing Mr. Palmer. There were just a few things I wanted to discuss with the court and Ms. Hall, so I was hoping I could at least put my announcement out at the appropriate time.
Okay, well, if you get Ms. Hall on the call, we can do that.
Okay, thank you.
Sure. Hey, Mr. Pinion, how you doing? You're on mute.
There you go. Thank you. I'm good.
Are you going to be handling Mr. Gooden's matter today?
Yes.
Okay, well, we're ready. You're not late. That was on the calendar for 10. It's a funny little calendar, 9:50, 10, 10:05, 10:06. But Odyssey is making it complicated for us to structure these things. We're trying to space them out so people don't have to sit on a Zoom call. We are waiting for the defendant who precedes Mr. Gooden. So while his lawyer tries to track him down, we do have Mr. Gooden available and Ms. Hornsby, his lawyer. So if you're ready, Mr. Pinion, we can proceed with Mr. Gooden's case.
I'm ready.
Okay, Ms. Hornsby, you ready to go? Ms. Hornsby?
Yes, Judge, I'm sorry, I had it on mute.
Okay. Well, we're going to go on the record now then in the matter of State versus Gooden. Mr. Pinion, last time we tried to work through this case, it was 19 SC 171376. And an attempt was made to enter a plea to 2 counts when there was, of course, only 1 count on the indictment. But that there's now a new accusation out there, and we'll get into the details in a moment. I know that when we were working through this last time, Ms. Moore and her family were connected. Do you know, or do we need to wait for them, or are they watching on Zoom? Because we do have the Zoom feed up. And that may be a question for Ms. Rolak. I want to make sure we're waiting for them.
Good morning, Judge. They're watching on Zoom.
Great. Okay. Then I think we've got everyone we need to move forward. So as I understand what we're going to do today is it's a repeat. It'll probably be a slightly abbreviated repeat because I learned a bunch about Mr. Gooden and the facts of this case when we were last together and Mr. Gooden entered a plea in the 19 SC case. But we now have in my hands. Nope, that's not it. There is a 20 SC indictment out there. I'll print it out. But there's a 20 SC 176482 accusation that charges Mr. Gooden with 1 count of traveling too fast for conditions and a 2nd count of failure to maintain lane. My understanding is the primary reason that we are doing a redo is that the sentence that I was asked to impose, and I tried to impose, but had to spread it across 2 counts when there was only 1 in the original indictment, was 24 months. And that was to allow Mr. Gooden sufficient time to pay a fairly meaningful amount of restitution that he agreed to pay. And so I think we're going to repeat a lot of what we did, but it's now in the context of 2 charges rather than 1. Is that your understanding, Ms. Hornsby?
Yes, Your Honor, it is.
Okay, Mr. Pinion?
Yes, Your Honor.
All right, well, Mr. Gooden, then I'm going to ask you to go off of mute, and we're going to do a lot of what you did before, but it's going to be with a different prosecutor. Mr. Pinion's going to put you under oath in just a moment. Once you're under oath, it's important that you answer all of Mr. Pinion's questions truthfully and completely, and that you let Ms. Hornsby or me know if you have any questions of your own. Will you do that, Mr. Gooden?
Yes, Your Honor.
Okay. Now, Mr. Gooden, I do need to make sure you're comfortable this time as you were last time proceeding remotely. You have a right to be here in court, but you are where you were last time. I see that same cityscape in the background. Are you waiving your right to be here in open court, Mr. Gooden?
Yes, sir.
You also have a right to have Ms. Hornsby right next to you so that you can ask her questions if there's anything you want to speak with her privately about. We can make that happen, but Ms. Hornsby is not right next to you. So we're clear. We can arrange for you and Ms. Hornsby to speak in private, but you and she are in different locations. You can see each other, you can hear each other, but you're not in the same place. Do you waive your right to have your attorney by your side during this plea?
Yes.
Okay, with that, Mr. Pinion, you can take over.
All right. All right, Mr. Gooden, if you'll please raise your right hand. Do you swear during this court proceeding on 20 SC 176482 to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. And is your name Octavius Gooden?
Yes.
And is that your true and legal name?
Yes.
Are you at this time under the influence of any drugs, alcohol, or medication?
No.
And how far did you go in school?
Some college.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that we are here today entering what we're trying to do is the exact same plea that you entered before, but on this indictment, the 20 SC indictment, there are now 2 counts, and they are both misdemeanors. Count 1, traveling too fast for conditions, and count 2, failure to maintain lane. So do you understand what you are charged with and why we are doing this proceeding again?
Yes.
Now, do you understand that just like the old indictment, you have the right to a jury trial on this, and you have the right to enter a guilty or a not guilty plea? You understand that?
Yes.
Right? You understand that if you enter not guilty plea, you have the right to a trial, and that at this, you would have the right to a trial by jury of 12 people. You understand?
Yes.
And have you had sufficient time to talk to your attorney, Ms. Avis Hornsby, about this case?
Yes.
And are you satisfied with her services?
Yes.
And have you discussed with her that you're waiving any potential defenses by entering a guilty plea here today?
Yes, we've discussed it.
And you understand by entering a guilty plea at a trial, you would have had the right to have your guilt proven beyond a reasonable doubt. You would have the presumption of innocence. You have the right to confront witnesses, the right to testify if you so desired, the right to remain silent, not testify if you desired, the right to present evidence, to subpoena evidence, and the right to appeal if you are found guilty. You understand by entering a plea here today, you're giving up those rights, the presumption of innocence, and the right to have your guilt proven beyond a reasonable doubt, and all the other rights that went over. You understand you're waiving all the rights to a jury trial by entering a plea here today.
Yes, I do.
Understanding what you're charged with and what rights you're giving up, how do you plead, guilty or not guilty?
Guilty.
And do you waive any defects that there may be in the indictment you're pleading guilty to, listing the 2 misdemeanors?
Yes.
Has your attorney advised you that the court could sentence you up to on 2 misdemeanors up to 24 months? However, this is a negotiated plea, and we expect the judge to give you the same sentence that he did last time, which was the recommended sentence, which would be probation and restitution.
Yes. Yes, I understand.
Yes, I heard you. Right, I'm just going looking. You understand that if you're not a U.S. citizen, that this could affect your immigration status.
Yes.
And you understand that while on probation, you cannot violate any of the criminal laws of Georgia or any special conditions of probation, or you could be subject to a revocation of your probationary sentence.
Yes.
And for Ms. Hornsby, this is not a first offender plea, is that correct?
That's correct.
All right. You understand that this just being a misdemeanor plea, Mr. Gooden, you would have only up to 12 months to file a habeas corpus petition challenging the voluntariness of this guilty.
Yeah.
And are you giving this plea freely and voluntarily?
Yes.
And has anybody threatened you to cause you to enter this plea?
No.
Has anyone promised you anything other than the recommendation by the state of what the sentence should be?
No.
Okay. Your Honor, I believe that completes the plea colloquy. I believe that you are certainly familiar with the case, and that this arose out of an incident in 2015, specifically September 16th, 2015, where the defendant was originally charged with a felony of serious injury by vehicle by driving recklessly. But after discussions with the defense attorney and myself and the victim's mother, the victim being Miss Moore, who was a juvenile, we agreed to these misdemeanor pleas. The incident happened on Barge Road in Atlanta, which is Fulton County, and therefore we would have venue. The defendant was traveling above the speed limit while he stated that he was sleepy coming home from work, and unfortunately hit Miss Moore, who was walking to a school bus. He did stay at the scene and has been cooperative and has stayed out of trouble since this happened back in 2015. I believe that's it, Your Honor.
Okay, Mr. Pinion, is this a matter that you have historically worked on? I know Mr. Abate took the first plea that we tried to sort out in this matter, but I think that was something of a cameo for him. Has this historically been your case?
Yes, Your Honor, and that the plea that the last plea that Mr. Abate took as a cameo, we actually had an earlier one that we started with, Your Honor, that was to the felony, and the victim's mother had indicated during the plea that she did not want to see this defendant have a felony on his record, and we asked for some time. We stopped the plea and asked for some time to see if it could be reduced to a misdemeanor. Mr. Abate, who had the authority to do that, did agree to reduce it to a misdemeanor, and because of a conflict I had for court that day, he stepped in to take that plea, which he authorized.
Okay, so you have been in touch with Ms. Smith, mom, and Ms. Moore, the victim, and are familiar with their sentiments about the case.
Yes, Your Honor.
Okay, that's just what I wanted to make sure, and I believe there are family members who are watching and listening, which is important for them to do. Ms. Rolak, excuse me. Does Ms. Smith or anyone from Ms. Moore's family wish to be heard at this time? I have a transcript from our last proceeding, so I was able to review what Ms. Smith had shared on behalf of her daughter. I'm happy to hear more or even hear the same if that's what the family thinks is appropriate at this time.
Judge, I did not ask them. I will check briefly and get back to you.
Sure. Sure. Why don't you do that, and I'll turn to Ms. Hornsby. Ms. Hornsby, anything you want to add in this situation? I recall what you shared with me, that Mr. Gooden has been working hard and is a man with many talents who intends to devote some of those talents to earning what he needs to earn to pay some of the medical expenses that Ms. Moore has had. But anything you
Yes.
want?
No, Your Honor, other than, I mean, I think the transcript speaks for itself. Mr. Gooden has been very consistent with checking on me because the plea didn't actually go through completely. We could not start probation, but he has been very active in trying to make sure that he, when can he start as soon as he can so that he can get this money paid. So as I stated before, I believe that this will be, he will get it done. He will get it done as soon as he can. And he is very, again, I've always said, very remorseful about this accident that occurred. And we're just asking that you take the plea that has been put forth and allow us, him to go on and start doing what he's ready to do and been ready to do in order to resolve this matter and hopefully somehow bring some closure of this situation.
Okay. Mr. Gooden, anything you want to share?
Just as Ms. Hornsby alluded to, there's nothing more that I can say to be as sorry as I was. And the only thing I can do is do my part that we all agreed to, and just try to do my best to make it right as best as I can after a very tough road.
Okay, well, I appreciate you sharing those sentiments. I think that is appropriate. It's what the family was expecting to hear. It's what they ought to hear. And I appreciate the way you handled this from the very beginning, not leaving the scene, taking responsibility. It's a sign that you mean to do well by Ms. Moore as best you can, and that this was a tragic accident as opposed to something more nefarious. So I appreciate that. Ms. Rolak, did you get an update from the family?
Judge, yes, they defer to the court and stand by their previous victim impact statement.
Okay. It is of the record. It'll be a transcript in the 19 SC case. They were sentiments that were well received and appreciated. And I'm going to repeat myself, but I think it has been important for Ms. Moore's family and for the system, the way they process that. It would be easy to remain bitter and angry at Mr. Gooden and blame. Of course, the fault is Mr. Gooden's. It was his accident, not anyone else's. But I've been very impressed with how Ms. Moore and her family have looked for a constructive resolution, one that makes Ms. Moore as whole as possible. And as I recall, she'll always have trouble with her gait, her ability to walk. But rather than viewing that as some burden and holding her back, she's trying to move forward. And just the way they have looked at this is, let's not hold Mr. Gooden back other than make him financially responsible for some of the things he did. It's refreshing and it's healthy because it shows folks are wanting to look forward rather than looking back in anger. So, Mr. Gooden, I do find there's a factual basis for your plea to both misdemeanors. I think you were driving too fast for conditions, you didn't maintain lane. I also find that your plea is knowing and voluntary. Voluntary means that no one is forcing you to enter this plea, but you've decided that it's the right thing for you to do going forward. Is that correct?
Yes, sir.
And a knowing plea just means you've understood all the things we've been talking about today and last time we worked through this. Do you have any questions about anything?
No, Your Honor.
Okay. Well, then I'll accept your plea. I will sentence you on count 1 to 12 months of probation. Count 2, 12 months of probation. Count 2 will run consecutive. That means after count 1. So it's a total of 24 months probation. Special condition of your probation will be to pay $10,000 in restitution to Ms. Moore. As I told you last time, you're not going to give her anything directly. You'll pay that through probation. They'll let you know the best way to do it. And they'll make sure that it gets to Ms. Moore and her family. I'm going to establish the same payment schedule I did last time, just so that you're focused on this And it's not the kind of thing that at month 23, you realize, uh-oh, I've got to come up with $10,000, because that doesn't give me a lot of leverage over you in that final month. So you will need to have paid a minimum of $3,500 within the first 6 months. And that clock does not start ticking until you're on probation. So it may not start ticking for a week or so. You will learn from Ms. Hornsby where you need to go, Mr. Gooden, to connect with misdemeanor probation. But you'll need to pay $3,500 within the first 6 months. You'll need to have paid an additional $3,500 within the following 6 months. So you'll be at a total of $7,000 within that first year. So if probation for you starts on October 15th, by October 15th of next year, you'll have paid $7,000 of the $10,000 that's owed. And you can get ahead, that's great. You can pay it off early. That's a reason to have probation end early for you, because this is the main focus of your probation. And then you will have $3,000 to pay in the 6 months after that. So it should be paid off by 18 months. If you miss any of those benchmarks, you and I, Ms. Hornsby, and Mr. Pinion are going to need to have a conversation about what's been going on. It could be, Judge, I've been working as hard as I can, but I got a job that pays $6 an hour. I can't do it. It could be you've been buying yourself fancy clothes and a new house, in which case I'll get frustrated and say you need to redirect some of that money to Ms. Moore, because that's your priority. After you're taking care of your basic needs, your family's basic needs, then it's Ms. Moore. I think you'll be able to do this, but I didn't want that structure to be in there. Any questions about that, Mr. Good?
No, sir.
Okay, it's the same as last time, so you shouldn't be surprised. I didn't mix it up at all. Mr. Pinion, are you moving to null pros 19 SC 171376?
Yes, Your Honor.
All right, I will take care of that. Ms. Hornsby, any objection to proceeding off a copy of the accusation in this case?
No objection, Your Honor.
And Ms. Hornsby, do you authorize me to sign your name and Mr. Gooden's name to that accusation when we finally figure out how to print it out?
You are authorized to sign our names. Yes, sir.
Okay, and Mr. Pinion, may I sign on your behalf?
Yes, Your Honor.
Okay, I think we've covered everything. Mr. Pinion, anything else on behalf of the state?
No, Your Honor.
Ms. Hornsby, Ms. Nelson will let you know what she knows about starting misdemeanor probation, and we'll rely on you to share that with Mr. Gooden so that he plugs into that.
Sorry. I'm sorry, everyone. Oh, I'm so sorry. Please forgive me. Oh.
Did you do that? You were breaking into someone's car?
No, Your Honor. I'm standing by my own car and it just went off for some reason.
Shot the alarm. All right, well, thank you for stopping it. But just to pick up where we left off, you will let Mr. Gooden know how to plug in with misdemeanor probation.
Yes, sir.
Excellent.
Your Honor, I just want to ask, since Mr. Gooden's basic, and I wasn't sure if we covered this last time, forgive me for not remembering. But when he pays all the restitution, because I suspect he will, and very quickly, can his probation be suspended that second year? If he gets it paid all within 1 year?
The answer is most likely, but that's the kind of thing that you'll need to file with me. I want to make sure there's no objection from the state, but I'm happy to get on the record now that what I view as Mr. Gooden's primary obligation is paying that restitution to Ms. Moore and her family. And if he's met that, there really isn't a reason for continued probation. Probation is sort of the prod to make sure that Mr. Gooden is paying it. If he falls behind, then I have some leverage to say, well, I'm gonna have you do some community service or do this or that until you start refocusing on this. So the answer is most likely yes, but you want to file something and we want to make sure everything else is going all right for Mr. Gooden.
Yes, sir. Thank you.
You bet. Mr. Gooden, anything else?
No, Your Honor.
All right, well, you need to get to work. You've got your work cut out for you. And Ms. Moore and your family, best to you in these complicated times. I will get the accusation signed, the final disposition signed, and we should be underway with this one. Thank you, everyone, with take two. I guess it's sort of take 2.5 of the plea in this case. Hopefully this one will stick.
Thank you.
Thank you.
Thank you.
Everyone, please stay safe.
All right, bye-bye.
Bye-bye.
All right, we have Ms. Hall on the call. She wasn't, I think, necessarily expecting to be dragged into this one, but I appreciate Ms. Hall dialing in. I think Ms. Patel wanted to talk briefly about Mr. Palmer. We'll do that, but let me get an update from Ms. Snyder, because we were supposedly taking a plea, and if we're not tracking down Mr. Taylor, we can let Ms. Sellers go. What did you learn from Mr. Taylor, Ms. Snyder?
Your Honor, I have called him several times while you were doing that plea and left him several voicemails, but he has not returned my calls.
Okay. So it's an issue of tracking him down, though. Have you been in touch with him leading up to today, or?
I spoke with him yesterday afternoon on the same number that I've been calling. I gave him all the Zoom information and told him what time to be on.
Okay. Well, what I think we'll do then, and I'll get Ms. Sellers' input on this, is set this down for a plea. Was this going to be a negotiated plea, Ms. Snyder?
Yes, sir.
Okay. And was Mr. Taylor going into custody, or would he stay out of custody?
It's a probation plea.
Okay. So there's not a reason necessarily for him to be shy about joining us. What we'll do is a notice calendar that will require Mr. Taylor to come to court, so that if he does not, or doesn't affirmatively let you know, yes, I'll be online, and he is online, I'll issue a bench warrant. But we'll set this out a few weeks and figure out some time that works for your schedule, Ms. Snyder, and your schedule, Ms. Sellers. Make it a notice calendar so that Mr. Taylor needs to be here, and if he's not, there'll be consequences. Is that all right with you, Ms. Sellers?
For a second. Yes, Your Honor. So it's my understanding that you would not be able to issue a bench warrant today, because that would be the state's request.
I can. It's just I'm not sure why Mr. Taylor, as of yesterday, was going to be here. And I don't know what kind of, if you all have been working on this for a while and this was not news to Mr. Taylor, it's down as an inquiry calendar. And that's the only reason why I was saying, let's try one more time. Sometimes inquiry calendars are with defense attorneys saying, I tried to find my client, and the answer is, because this is a 15 SC case, the information is stale. It's 5 years old. That's not what we're hearing. Ms. Snyder was talking with Mr. Taylor as recently as yesterday. So the other way we could handle it is issue a bench warrant, but let Mr. Taylor know that as soon as he walks in here, I'll rescind that bench warrant and we'll take the plea. Sort of achieves the same thing. I just need to get Mr. Taylor in here so that we can resolve the matter.
Your Honor, I will defer to the court. I do remember that Mr. Taylor was present at one of these calendars, but I will defer to the court as it relates to whether to issue a bench warrant.
Okay. Ms. Snyder, anything else you want to add as to Mr. Taylor?
I would ask that you not issue a bench warrant, given this was just an inquiry calendar to discuss whether I had received the rest of the discovery. And we just, the state gave us an offer and we decided to enter a plea. So I would ask we don't issue a bench warrant and give me a chance to get him on and bring him in with a notice calendar.
Okay, we'll do that. It'll be short notice. I mean, it has to be a certain number of weeks, but we won't punt it out to December.
Yes, sir.
Are there discovery issues that will make taking the plea complicated, or the offer is such that that should not be an issue, Ms. Snyder?
It shouldn't be an issue. The only issue in the discovery was it referenced a supplemental report that I didn't have, and Ms. Sellers has since given it to me.
Oh, so you've got it. Okay.
Right.
Well, then let's do that. We'll get a date soon for Mr. Taylor. Do you know if the address in the system is the correct address for Mr. Taylor, Ms. Snyder?
I believe it should be, because like Ms. Sellers said, he did appear in person before, so he's received notice.
Okay.
I'm checking the notices now, Judge, just to confirm if he actually received the notice.
Sure. It's an apartment on Riverdale Road that we've got.
Your Honor, I hope I did not miss anything. I was on the phone with the victim.
No, you didn't miss anything. Ms. Nelson was just checking to see if she had any intel about the validity of Mr. Taylor's address in the system.
Okay.
And I don't, Judge, I don't see that he received notice.
Well, we'll still set a date. Ms. Snyder has a phone number that as of 18 hours ago worked for Mr. Taylor. We'll send it to the address of record. And if Mr. Taylor is in court for the next calendar and still wants to go forward with the plea, we'll take the plea. Otherwise, we'll just have to delay the bench warrant by a few weeks, but that will be the result of a no-show. Okay?
Yes, sir.
All right. Thank you, Ms. Sellers. Thank you, Ms. Snyder.
Thank you. May I be excused?
Yep.
Have a good one.
Have a good one. May I be excused, Your Honor?
Yes, ma'am. Thank you.
Thank you. Thank you, Judge.
So let's hear Ms. Patel about Mr. Palmer. And
Yes.
as I understand it, Mr. Palmer is the co-defendant. I've met Mr. O'Neill a bunch of times. This is the guy with the broken leg, a stolen van, the van crashes, and Mr. O'Neill is either in the van or he coincidentally is right outside the van when it crashes. So this is the co-defendant of that guy?
Yes, Your Honor.
Okay, I don't know that I ever met Mr. Palmer. I feel like we've always dealt with Mr. O'Neill.
I don't believe you have because he was taken to DOC, I think in February. And so we would never have had him come to court at that point.
Okay, so what did you want to say? He was on for a final plea, which we're going to have to reset at a minimum because he's in state custody. What else did we want to talk about?
I just wanted to put on the record the discovery that I am missing.
Okay.
I am missing medical records of any of the individuals involved in this incident. My understanding, based on the indictment, is that they are trying to proceed with a count of serious bodily injury, and that count lists the person as unknown. And so we need information as to that. That count probably needs to be re-indicted. A 911 call, ballistics. There was a firearm discharged and we don't have a report on that. Mr. Pinion indicated, because he initially had this case, that there were some search warrants done. So we need copies of those warrants, photos, and jail calls.
Let me play that back. Medical records of any victim, if there was in fact a victim. I'm pulling up the indictment because I didn't know. Oh yeah, so count 8, there's an accident which was the proximate cause of serious injury to unknown. And then someone unknown failed to, yeah, count 8's interesting. Okay, but your question, Ms. Patel, would be, or your request would be, if in fact there was someone injured as a result of count 8, could we please have medical records of that mystery person?
Correct.
Okay, 911 calls, if any. Ballistics, which means what? Is that a gunshot residue, or do you know was a gun seized? Just the fact that a gun is fired doesn't necessarily mean that a report is generated.
So there was a firearm that was seized and I believe a shell casing that was recovered. So if there was any sort of analysis as to that.
Connecting gun to shell casing. Correct. Okay. And then you say, Mr. Pinion said there were some search warrants. You don't know if it was of your client's house or the co-defendant's house or what. You don't have any of that?
Yes, that he indicated that the search warrants were for the victims, I suppose maybe for their medical records, or I'm not sure though, but he said that they had done some search warrants in this case.
Okay. Sometimes I guess the DA's office might do a search warrant to get medical records. You might be entitled to the results of the search warrant, but that's nothing that you'd be able to suppress. I don't know what your standing would be, but we'll let Ms. Hall answer that in a minute. And then jail calls, you have reason to believe they're jail calls, or this is just a CYA request?
CYA request.
Okay.
And then also photographs. I believe that there was a tech on scene.
Okay, well, I have some good news on the photograph front, not specific to this case, but I have learned that APD no longer has this inexplicable embargo on generating photographs from a digital lab during the pandemic. That photographs that crime scene techs took should be much easier for the district attorney's office to obtain. But Ms. Hall, let's go through those. And you may not have been expecting to have to talk about Mr. Palmer because you may have gotten wind that there's not going to be a final plea today because he's in the state system. But we're still going to need to work through these things. So if you need to get back to Ms. Nelson and Ms. Patel by email, let me know. What's going on with count 8? An unknown victim, an unknown driver, or are you hoping to make count 8 go away?
Well, Your Honor, I don't know why there's no name there because we have a family of 4 that were injured in the accident. Castino is the family's name. I'm not sure why the complaint room didn't add that since we knew who they were when this accident occurred. Ms. Patel did, I was speaking with her during that plea, so she did bring it to my attention. I didn't catch that. So our intention, and I believe this is why the case initially was in major case, but the injuries weren't as severe as they initially thought. So now it's back in trial division, but I will get on that and decide whether we're going to move forward on that. I need to speak with the family to see what's going on with their injuries. We are still waiting on medical records for them though.
Okay, so that helps me understand. And as I look at it, actually count 8 does not implicate Ms. Patel's client. Doesn't mean she shouldn't get the medical records, but it's only Mr. O'Neill, who I assume was the state's theory is he was the van driver. It does not charge Mr. Palmer, but right. That's the universe of medical records. It could be that count 8 is insufficient in the sense that if more than one person was injured, there may need to be multiple counts of hit and run resulting in serious injury. Could also be that count 8 goes away because you conclude, Ms. Hall, that just the injury wasn't serious. So you're probably. But you need to get those medical records. How about 911 calls?
Your Honor, and me and Ms. Patel just had this conversation. You know, we're very familiar with this case as a whole, not particularly Mr. Palmer. It was my understanding that we had everything other than the photo labs and the medical records. So I told her I would go down to the office and look in the physical file because it was a lot going on with even Mr. Wright saying that he received some things and didn't receive others. So I will personally, and not have my legal assistant do it, but go look at the file and see what's in it. Because I know we have a 911 and it was served. I don't know, like I told Ms. Patel, I'm not sure why she didn't get it, but her client wasn't as involved with our many court proceedings as Mr. Wright's client or as the other co-defendant. So maybe that's what happened with my legal assistant not getting it to Ms. Patel, but I would check on that. I will also, I didn't pull any jail calls, serve any jail calls other than me listening to them. So I will serve that to Ms. Patel. We did get information yesterday. I was wondering if you had something to do with it, but we did get information yesterday as far as getting photos from APD now. So I will be able to get her those photos from APD. I just need to reach out to the lead investigator for that. But yes, so I understand the discovery issues, Your Honor, especially for Palmer. I'll start working on the things that Ms. Patel is missing. She has received some things, but there is a lot that she doesn't have that I wasn't aware of. So I'll get on that and make sure she has it if it exists. I'm not sure of any search warrants though.
Say that because I was just about to ask that. What about?
I said I'm not sure of any of the search warrant situation. I'll reach out to Brett and see what he was referring to. I didn't see any mention of it in the reports and stuff that I've read and the videos that I've watched, but I could have missed it. So I'll reach out and see what he was referring to.
Yeah, it didn't sound like the kind of case where there would have been a search warrant of either Mr. O'Neill or Mr. Palmer's homes.
Right.
It's a single incident. So whatever they had, if they were involved. But if you could confirm that with Ms. Patel. And then finally, make sure you check with GBI. I don't know what's going on with the gun and the shell casing.
I will, Your Honor. And I don't believe a shell casing from the gas station was ever recovered, at least not from the videos that I've watched and the conversations I've had with the investigators, but there was a gun recovered at the scene of the accident. So I will check to see what happened with that information.
Okay, and then refresh my recollection, because you're right, we were always focused on Mr. O'Neill. Was Mr. Palmer in the van that crashed, or what's his connection to the van?
So he was really the only description given at the gas station. He was the one that was described to have on a red hoodie. And then when the van crashed, he was either knocked unconscious or just didn't get out. So when the police arrived, he was still in the passenger seat of the van.
Okay, all right. So Palmer was found in the van wearing a red hoodie?
I'm sorry, what'd you say, Your Honor?
Was he wearing the red hoodie in the van?
Yes, Your Honor.
Okay, all right. And O'Neill was outside the van with the busted leg?
Yes.
Okay.
And he had made it down the road, and that was the big discrepancy as to whether he was a pedestrian or the driver.
Yeah. Okay, got it. Ms. Patel, anything else you want to add in connection with that? It sounds like Ms. Hall is on it. Some of the stuff she may have and it'd be easy to get to you. Some of it, maybe they're still waiting on it, and we may carve out the whole serious injury from the case anyway, although it doesn't seem to implicate your client directly.
I have nothing further to add. I would just, for the court's edification, Mr. Palmer's parole ended today. I spoke to his mother, and the Fulton County hold is there. I'm not sure if they're picking up people from DOC or not, but he is ready to be picked up.
Okay, they are. That's unfortunately how we lost 2 deputies a few weeks ago, is that they are having to get people when their state term is up if they still have a Fulton hold. So Mr. Palmer will get back here at some point. That'll make it a whole lot easier for you, Ms. Patel, to interact with him. What's the next step for the case? Ms. Hall will push you this discovery. Assuming there are not search warrants, or the search warrants are limited to things like medical records, which wouldn't pertain directly to your client, is there a reason we cannot put this down for a final plea, or what would you request on behalf of Mr. Palmer?
It's difficult because when I first met my client, I didn't even have a police report. And so we haven't had a chance to even talk about any of the substance of the evidence. And it could be that I end up filing 10 motions and this is on track for trial, or it could be in a different direction. So I would just ask that if we do go in the direction of having motions, that I have the time to review the discovery and file those motions, and that maybe they be heard before final plea if possible.
Okay, that makes sense, but what discovery, what would you be getting that you don't have that would be the basis of a motion? Or is your point, I need to talk to my client before I file motions? Because 911 call, that's not going to be a motion to suppress. Ballistics, not a motion to suppress. And assuming, even if there were search warrants, they're for medical records. Again, you're not your client, so there's nothing to suppress. What, you just want some time to talk to your client?
Talk to my client, and also, I don't know if any lineups were done. If they were done, we would be seeking to have a motion on those. So one, I just need to have a conversation, but I don't have any information about whether there were lineups done with the victims. If there were, we would just be addressing those in court. I don't see any evidentiary suppression issues coming up. But again, I'm just not sure what, if Ms. Hall ends up getting a large investigative file and that there's more to it than what we have.
Okay, it doesn't sound like it, but what I'll do is we'll do a revised scheduling order, I guess, that gives you a motions deadline to file something that would accommodate your desire, understandable desire to talk to your client before you decide. It may be that you are on again. Let me look here. If I go to summary, yeah, you're on a Mr. Palmer and Mr. O'Neill are on a November 16th final plea calendar. I think I'm going to leave them there. It's more than a month away, and we will certainly take Mr. Palmer off that calendar if you've determined, Ms. Patel, that there are substantive motions that have to be heard and resolved prior to final plea. But let's keep that as a placeholder so the case continues to move along, so that when we are able to try cases, this could be one that is as ready as can be. Okay?
Okay.
All right. Ms. Hall, anything else in the Palmer matter?
Nothing further from the state, Your Honor.
All right, Ms. Patel, anything else?
No, Your Honor.
All right, thanks for calling in. That leaves Mr. Dean. What I have on my schedule is that WebEx is not until 11:30. Is that right, Ms. Nelson?
Yes, Judge. I didn't know quite where to put him since he was already on the calendar and we had to arrange the WebEx. So that's why it's a little bit later.
Oh, smarter for it to be later than we just talked through it because something else took longer. So we will all connect via WebEx at 11:30. Mr. Franklin, good morning. Is there anything we need to talk about Mr. Dean's case before we get him online at whatever facility he's at?
No, sir, I think everything can wait. We have him present. I know that we do, looking at the Odyssey system, I saw that there's a trial date for January 7th. I know most of this stuff is pretty ambitious, but he currently has a max out date of December 30th, and that trial date is out.
So I appreciate you flagging that. Let me give you all an update, which you are free to share with colleagues. The first jury trial in Fulton County Superior Court will be a criminal jury trial. It will occur in either 1D or 1C. It will be the week of January 11th. It probably won't be one of our cases. It will probably be a case with a speedy demand, one that was pending prior to the pandemic, but we will be unable to, we will not be getting jurors into the building until January 11th. And I hope we'd be getting in enough jurors to try two things, one in 1C and one in 1D. That's not currently the majority view of our bench. And it would be jurors enough for one trial. It doesn't really matter which of the two big courtrooms it's in. Ms. Nelson and I will be soliciting from the lawyers assigned to this courtroom, so you, Mr. Franklin, Ms. Patel, Ms. Hall, Ms. Snyder, a list of 3 or 4 cases that we could have as ready to go for that week of January 11th. In looking at the speedy trial demands, I suspect that almost all of them will go away rather than be trials. We do not want to figure out how to get jurors down here and not use them. It will be a real important learning experience for everyone involved, lawyers, parties, jurors, court, sheriff, etc. So we need to have several backups to whatever speedies might be selected to go. And if you all are comfortable trying a case, and there's one, it would need to be a jail case, and it can't be a particularly complicated one, so not a 18 defendant gang case or a spree case, but something, and it won't be this one, but Palmer and O'Neill would be one where you could do that in a week. So you'll get an email from Ms. Nelson or me saying, think about your clients who've been in for a long time, who the only way they're going to sort this out is a trial, and it can be a homicide. It just can't be one where you think realistically it could be a longer than a week trial. And we'll have that case or a couple of our cases on warm standby if whatever speedy is going to be done down here falls apart. So that was a long way of saying Mr. Dean will not be on a January 7th trial panel.
Okay. Okay, the mute came on and off.
You're on. We don't.
Okay. So are we to presume in that analysis that the jury selection would likely take 2 days to ensure that we're trying to be socially distant and all that kind of stuff, because that would evaluate which cases I have that may be triable within a week? Most of the stuff I have,
and we're spending a lot of time thinking about the logistics of voir dire. If we're only doing one trial, and so bringing in jurors just for one, we might be able to get through voir dire in a single day. But given the complexities and probably the number of for-cause hardship excusals that will flow from this, it may be that voir dire could take 2 days. And I want to be clear, it's okay if the case spills over to a Monday, but if you know going in, this is just a bruiser of a case and it's going to be 50 witnesses for the state and 20 for the defense, that is not the right case to start with. But I suspect you in particular, Mr. Franklin, have a number of homicides. I want to stay away from real messy CWAC cases because that just makes jury selection even more complicated, as you know. We'll lose enough jurors because of hardship that we're probably not going to have enough to then lose a bunch of jurors because they cannot be fair in the face of a child molestation allegation. But armed robbery, bank robbery, homicide, again with an eye to, if someone's been in jail for 1.5 years or longer, we ought to try that case ASAP. And I'm comfortable elbowing us to as close to the front of the line as we can, just to get some closure and something like that.
You're on mute.
My only other question for today, when we get on the WebEx, will that also be live streamed on YouTube? I gave the YouTube link to Mr. Dean's family.
I don't think we have that function. So what we could do is have one family member dial in and just do audio, not show up video, but just listen in. But I don't think they support the YouTube feed function. They just recently added breakout rooms, which is great because the way DOC had to do it, you probably experienced it, Mr. Franklin, is that your client is handed with like this red phone, bat phone, but you have to get off the WebEx and dial that number. They tell you what the number is to a private phone conversation. WebEx, desperately trying to keep up with Zoom, has added a breakout room feature. That doesn't fix your problem or your concern, but do know that we can have a breakout for you and Mr. Dean if you need it. But I think what we ought to do, if it's important for family to hear what the discussion is about, would be to have them dial in, meaning use the WebEx link. My request would be that they not connect video-wise. They can watch the video, but the signal degrades pretty quickly, I've found, if we have too many tiles with the actual video back and forth, if that makes sense.
And
You're on mute.
I don't know what's happening. I'll give his parents a call and work out those logistics between now and I think he said 11:30.
Yep, 11:30. All right. Anything else, Ms. Hall?
Nothing further from the state.
Okay, well then 11:30, we'll see everyone on WebEx. Appreciate it.
Bye.